Hello everyone, my name is Teevranshu Vashishtha and I am a second year law student at the West Bengal National University of Juridical Sciences. Currently, I am an intern at ubAdvocate under the guidance of Advocate Mr. Jeevan Prakash. Today, I am going to talk to you about some of the basic ideas or principles that are listed in the Transfer of the Property Act that was enacted in 1882. In today's video, I am going to discuss what are the basic definitions or simple explanations that are given in these sections. First off, we are going to discuss Section 5. Section 5 of the Transfer of the Property Act talks about what is the act of transferring a property. It says that when one person gives or conveys to another a property that he owns, such an act of giving or conveying is known as the transfer of property. This section says that one person can transfer his property to one or more than one living persons. In this section, the definition of living persons also includes organizations, body of individuals, or companies. This section also says that a person can transfer a property to himself, but that he can do in a different capacity. That is, A transfers his property to his son S, but he accepts that property on behalf of his son's legal guardian or parent. Second, we'll talk about Section 6. Section 6 of the Transfer of the Property Act basically talks about the rights or the properties that you cannot transfer. This section says that the right to maintain is a non-transferable right. The right to spes succession is a non-transferable right. The right to sue is a non-transferable right. The right to re-entry is a non-transferable right. An easement right is non-transferable. A limited or a restricted right to enjoy a property is also not transferable. Public office is not transferable. Stipends or pensions that are received by persons that are given to them by the government are also not transferable. Also, the right that a tenant have to occupy or to enjoy a piece of property is also not transferable. Now let's talk about Section 7. Section 7 of the Transfer of the Property Act talks about who all are competent in the eyes of the law to make a transfer. That is, the person who transfers a property, whether their transfer is legally valid or not. This section states that any person who is legally capable of making a contract can transfer a property. This means that those who are not of stable mind or who are of unsound mind cannot make transfers of property. Those who are not major in age, that is, who have not yet passed the 18-year age limit, are also not eligible to transfer a property. This section also says that any person who has been authorized by another to transfer his property, such a transfer, if done, is also valid. That is, for example, if A gives his permission to B, that B can transfer A's property. So in this case, if B transfers A's property to another, this transfer would be held valid in the eyes of the law. So I hope whatever I explained to you in this video was basic and I gave you a precise idea of what is written in some of the sections of the Transfer of the Property Act and what is the act of transferring a property and who all you can transfer it to. What are the rights or the benefits that you cannot transfer and who all are competent in the eyes of the law to make a transfer. Thank you.